Oh, things are happening in Bartz v. Anthropic. We have the document that they're going to send up to the Ninth Circuit for the appeal. We're going to look at that, but not today because something else big came through. The other day I saw an order to them from the judge saying that they need to respond to their advice of counsel defense. I was like, what the hell is the judge talking about? They never made an advice of counsel defense. Well, apparently there's a document that didn't get up on recap because not all of them get up there for some reason. The plaintiffs are trying to claim that they made this, and if you don't know what advice of counsel is, basically it's like, I want to know if I'm doing something, if what I want to do is illegal or not, so I'm going to ask a lawyer. The lawyer says it's fine, so you do it, and then you get dragged into court about it. And you say, well, my lawyer said it was okay. That doesn't necessarily mean you get away with it, but it does mean that you don't have intent or volition or anything like that. It can be a big mitigating factor. The problem is, that's one of the few ways to pierce attorney-client privilege. Because that means that any conversations you had with your lawyer relevant to that, where he said, yeah, okay, you can do that, that has to come into evidence. Because you can't just say, hey, a lawyer told me to do it and that's that. You have to back it up. So that pierces attorney-client privilege. Anthropic never said one word about that, but apparently the plaintiffs are trying to make it that way because, again, they have nothing. They're getting more and more desperate. They're trying to pierce right through attorney-client privilege. And Anthropic is here stopping them. And this is another way that these cases can threaten all of us. Because any chinking away at attorney-client privilege and other rights like that can affect every single one of us. So this is Anthropic's response. It's a 17-pager. We're going to start over on page 5, where Anthropic basically has the same reaction that I did. Anthropic has not invoked an advice of counsel defense in this case and does not intend to do so. Its assertion of affirmative defenses of innocent infringement and volitional conduct does not put any attorney-client communications at issue, and so Anthropic has not impliedly waived its attorney-client privilege. Plaintiff's contrary assertion is legally and factually baseless. So how are they doing this? How are they trying to pierce that veil? Well, Anthropic's witnesses will testify that, based on their general experience, including prior employment, they believed that downloading books from the internet was fair because they were not reading or distributing the books and were using them for a different purpose. Because again, if it's for a non-infringing purpose, that's a fair use. And so basically what plaintiffs are saying is that just that belief means that it's advice of counsel and they get to pierce that veil. But Anthropic says they will not testify that they relied on advice of counsel. Plaintiffs do not contend otherwise. Instead, the premise of their July 24 letter seems to be that any assertion of an innocent infringement defense automatically waives attorney-client privilege over any relevant attorney-client communication. By which they apparently mean any attorney-client communication related to the alleged infringement. That wildly overbroad theory ignores Ninth Circuit precedent, which is pretty doggone solid in this, and would render the innocent infringement defense an automatic waiver of the attorney-client privilege. Because plaintiffs have waived any theory of copyright infringement based on the output of Anthropic's generative AI models generated by its users, remember that they've given up on this whole outputs are infringing nonsense. You've still got Reed Southen or Southen or however you pronounce his name. I don't care how you pronounce his name. He and so many others are still on the socials saying that. Whereas they've had to back away from it because it's not true, because it's not how it works. So because of that, Anthropic does not anticipate the volitional conduct will be an issue at trial. Regardless, that defense would not put attorney-client communications at issue either. Back in 2024, last year, Anthropic answered plaintiffs' complaint and we asserted defenses. Plaintiffs have accordingly been free to explore the basis for these defenses. Anthropic responded that it would produce all non-privileged documents. Anthropic does not intend to rely on any privileged documents. Plaintiffs raised no objection to that response. Plaintiffs have made no effort to explore the basis for Anthropic's innocent infringement or volitional conduct defenses. Plaintiffs sent their July 24 letter to this court taking the position that By asserting privilege over materials relevant to these affirmative defenses, Anthropic had selectively used privilege as both a sword and a shield. In that letter, plaintiffs used misleading language to falsely imply that they were unaware until Anthropic's most recent privilege log that Anthropic was asserting privilege over specific communications from the time period immediately before Anthropic downloaded books. While these documents from 2021 appear on the privilege log because it is cumulative, they were first added to the privilege log back in March, and plaintiffs should have known about them since then. And once again, just for good measure, Anthropic has not invoked and does not intend to invoke an advice of counsel defense in this case. So they go over the precedents, which are pretty solidly on their side. And over here on page 9, they say plaintiffs do not cite any Ninth Circuit cases finding implied waiver simply because the defendant has invoked an affirmative defense relative to state of mind or because privileged communications might bear on a party's state of mind. It is beyond dispute that someone can have a belief on a topic, even a legal topic, independent of conversations with counsel. Hey, I certainly do! What am I doing right here? Alright, so over on page 12, state of mind defenses are common in the law, especially in IP cases, and it would gut attorney-client privilege if parties were precluded from offering arguments and evidence about their state of mind unless they were willing to waive privilege. The innocent infringer defense, which Congress expressly created via statute, would be a dead letter if merely invoking it, as Anthropic has done, always results in the waiver of attorney-client privilege. Plaintiff's theory has no limiting principle. In other words, it will let them go in and just go through everything. And that's what they want. They just want to go through and pull out anything that they could just pull out of context and use, like they've done in other ways in these cases, where they have a discussion about, is this a good way to do it? Well, I don't think it's do it. Well, see, so-and-so said that they should be doing that means that they knew they were doing something wrong. And there's also another case I won't mention the name of because I don't want to get shadow banned. But it was a big one where they tried to pierce attorney-client privilege by saying, hey, this guy's own lawyers said that he was doing it wrong. When some of them said that and others disagreed. And lawyers disagree all the time. So if they can do that, if they can pierce that veil and go through and find some lawyers disagreeing, and they can pop forward and say, see, that means they knew they were doing something wrong. They've tried it before with attorney-client privilege. They've tried it in this case with non-privileged communications. What the hell do you think these assholes will do if they get to pierce attorney-client privilege? It'd be bad. And it'd also be bad for you and me, because that means anyone with a mind to sue us could do the same thing. But more than that, the rule plaintiffs propose would deter people from seeking legal advice. It would have a chilling effect. As to fair use or the legality of their actions more generally, particularly when they already held a belief that their use was fair or legal, because they could lose that defense by learning more about it from counsel. That's the chilling effect, and that's an outright absurdity. And the Bartz plaintiffs are all like, but Your Honor, we need to know that because we need to know about their state of mind. But Anthropic says, it is frequently the case that access to an adversary's privileged communications might assist a litigant in proving its case or disproving the adversary's contentions. But the whole point of attorney-client privilege is to protect relevant documents. When communications are not relevant or responsive, they need not be produced in the first place. It's kind of like they say sometimes about freedom of speech. Well, this freedom of speech is good, but we don't need freedom of speech for this other thing because it's bad. You don't need free speech protections for things that everyone agrees with. You need the free speech protections for the unpopular speech, the dangerous speech, the disruptive speech. That's when it's most important. Same with attorney-client privilege. You don't need to assert privilege on documents that are irrelevant because irrelevant documents don't come in anyway. Attorney-client privilege only really matters when documents are relevant. Bottom of page 13 of the PDF. Anthropic's witnesses will testify that, based on their general experience, including in their prior employment, they believed that downloading books from the internet was non-infringement and was fair because they were not reading or distributing the books and were using them for a different purpose. And remember, the claim of distribution, the claim of seeding, that's in a different case. That's over in Cadre v. Meta. This is Bartz v. Anthropic. Okay, let's pop on over to the last page, page 15 of 17. Just a couple of signature pages after that. Anthropic does not intend to argue to the jury that it stopped training models based on advice of counsel. That is, it will not be asserting reliance on counsel for either the decision to download books or the decision to stop using such material. In any event, plaintiffs are not suing Anthropic for its decision to stop using books for training. Accepting their suggestion would have the perverse effect of disincentivizing people who are engaged in ongoing activity to consult their attorneys about it. The chilling effect again. As for the volitional conduct defense, to the extent plaintiffs argued that Anthropic had committed copyright violations based on a model's output based on user input, Anthropic had intended to rely on that defense. Because plaintiffs have expressly conceded that they are not making any argument about output, they've already lost on that and they know it. And remember, that was completely dropped over in Cadre v. Meta early on. None of this has anything to do with outputs, remember that. Anthropic does not anticipate that the volitional conduct defense will be an issue at trial. In any event, that defense does not even relate to attorney-client privileged communications, has nothing to do with advice of counsel, and certainly does not put attorney-client communications in issue. So once again, we see how desperate these plaintiffs are. We see the lengths that they'll go to. We'll see the way they threaten the basic human rights of you and me. And if they're not stopped, not only will this have a major effect on AI, it'll have a major effect on the rest of us as well. Every time you're pulled into court for anything, you would feel the effects of it. And you'd be much more likely to be pulled into court because someone would be much more confident that they could get you on something completely baseless, which is exactly what all of this is intended to prevent. And yet, once again, I'm the only YouTuber talking about it. So if you want to keep me talking about it and keep me doing it and give me good thanks for doing it, then please, comments for the comment god, shares for the share throne, like, subscribe, the bell, and donate.pagosity.tv. All of it keeps me doing this, whether it's one-time donations, big or small, or becoming a supporter, Patreon, Subscribestar, or Discord. Get these videos early and ad-free. Thank you so very much for watching. Until next time, stay strong and be free.